Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun, enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions and lemonade. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proced, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. I'm already having technical difficulties, but that's okay. Good morning. Happy. It's Thursday. Today's Thursday, October 24th. We're here for it. We're here for day 5 of the Sarah Boone trial. I think it's day 5. Today, we expect the defense to rest this morning, and then we're going to see the state's rebuttal case. How is everyone? Oh, morning wouldn't be a day without technical difficulties. Let's hope I don't swipe myself out today. Just make sure my fingers aren't sticky, because that's the problem, I think, on this mouse pad, or whatever you call this little thing down here on my laptop. Okay, let me see. Camera's up. I just saw Sarah walk into the courtroom a couple minutes ago. How is everyone today? Thoughts, concerns? Thought of the day? Deep Thoughts with Jack Handy. Let's do this and good morning. Good morning, cupcakes. Yeah, Fios has been having issues too. I don't know where you live, Melissa, but Fios has been out a lot. And I don't even live in a hurricane zone. Well, at least for the last 2 hurricanes, but good morning, Judge. Good morning, Judge Kranick. See how many times he says, God bless you today. Did you hear about the state's request regarding a conflict of interest with the defense? They did mention that briefly yesterday. They mentioned something about a conflict, but they never really got into it, right? I think they said they were going to get into it today, perhaps. Thank you, Charlotte. I don't know if you have any further details. Good, extremely early morning. Where are you, Miss Scarlett? You on the West Coast? How about a Yankees-Dodgers World Series? How about that? They're going to be the most expensive tickets, I think, in World Series history. That's what I think. That's what I'm thinking. Linda's a mess with this case. She doesn't know. They filed a motion yesterday. The state did. The defense rested in Quinton Simon. I saw that as well. No witnesses, right? And she didn't testify, so that's over. So I guess their case is going to the jury. Go Yanks. Conflict of interest. They say that, oh, I heard, you know what? I saw a brief blurb about that this morning, that perhaps he's getting paid in media rights or something. I mean, I don't know if it's that uncommon. I think lawyers do that. So I don't know. Haven't seen the papers. I haven't seen the papers on the motion. So I guess if they're gonna talk about it, we're gonna hear it. We're gonna hear it all. Does anybody know if you've been watching the Recovery Addict trial that he's streaming? Something happened in that trial. I think it's the Farris trial. And I don't know. I don't know. I'm a little confused about this, so maybe you guys can tell me if you know, because you're so collaborative here. Recovery Addict is streaming that trial, the Melody Farris trial, and there's something about a gun. And then there was a woman apparently who was watching his show, and she said, I was watching a YouTube show, and there's this little man in the courtroom with headphones commenting about the gun. And then I found out that I'm the one who gave her the gun, or something like that. He like cracked the case. Good morning, Snark Tank. Good morning, Crazy Cat Lady. Jules didn't know I was covering this. I don't know why. I don't know why she wouldn't know. It's public knowledge on YouTube. She was down for a while with the hurricane and service and power and things and stuff. So I'm glad she got to get over there. Yeah, do you guys know anything that happened with Recovery Addict about the gun? It's her aunt. Okay, Michelle. So her aunt was watching Recovery Addict stream the trial, and she heard Recovery Addict say something about the gun. And that's how she came forward. It was a family member that the defendant had taken care of and was the only one who knew where the gun was. So I don't know. Okay, here we go. Recovery Addict realized where Melody likely got the gun and blurted it out. The homeowner saw it on his show and realized he was probably right, so she called the police. Wow. See? The YouTubers that cover trials really are providing a very excellent service, aren't we? Also, not only for things like that. I mean, that's probably the best thing ever that's happened, right? Because usually they cause trouble or maybe do get in the way of investigations sometimes and searches, but also sometimes, a lot of times, they're watching you guys. Both sides, prosecution and defense, is watching the chats because you guys are the mirror jury and they want to know what's working, what's not working. And you're the ones who tell them a lot of times how their case is going. Carly says the stepmother of the man the defendant was having an affair with said she told the defendant where the gun was, and then the gun disappeared. Well, the fun probably disappeared too, but I think you meant gun, right? Oh my God, that's crazy. So, and the case is on trial, and this is going to be like a wrench thrown into the trial. I love this. It was great. Recovery Addict said, oh, that's where she got the gun. And then the woman came forward. Wow. Is it going to delay the trial at all, or is the trial still going full steam ahead? An elderly woman called the police. That's true. That is true. A YouTuber found Riley Strain's debit card. I remember that. There's good that comes from YouTubers. I know we get a bad rap. All I'm trying to do is create a nice community here of really nice people who support each other in the chat like you did yesterday. We had a viewer who told us that she was going through breast cancer. You guys were amazing. You're always amazing. And look at Denise gifting 5 memberships. Thank you so much, Denise G. And to ever of you who were gifted memberships, welcome. All right. No danger of Alec Baldwin coming forward on trial. Alec Baldwin, are we talking about? Melody Farris is a despicable. I haven't been following that one. Are you glad we covered this one instead of that one? I don't know. Hindsight's always 20/20, you know? The jury is going to the property today on that Farris case. Okay, so that Farris case thing, I think it's been going on for a while. So they're going to the site view today. Yeah, I think the site view makes more sense later in the trial sometimes. Remember in Karen Reed, they went in the beginning. And also, I don't remember in Murdoch when they went to Moselle, if it was in the beginning or the end. It depends on the case, but I mean, sometimes it helps to see the scene after you've heard a lot about it, and then you go there. And then sometimes it's good to go first, and then you already know about the scene, so you know all the things that they're talking about. And when they say, Officer John O'Keefe's body was found this far from the bedroom window and nobody came outside the house, you really have a better idea of what they're talking about, right? I did watch some of that last night, Alana. The new Massachusetts or the Norfolk County DA candidate was on the Young Jerks last night. If you have not watched it, go back and watch it. She was good. If I lived there, I would donate to her campaign. She gets it. She gets it. And he talked to her a lot about the Karen Reed case and what she would do and why you know, did she think it was unusual for them to go out and hire Hank Brennan? And she said, I know Hank Brennan from the DA's office when I worked there. He's a great guy, but usually you only hire an outside counsel or special ADA when you have a conflict, and they don't have a conflict. She's a little confused about it too, but it was interesting. Oh, it is a nice community. Thank you, Crunchy Frog. Okay. The lady who came forward said the gun was in the guest bedroom dresser and other things were missing. Ooh. Ooh. Hi, sweetie. I don't know what the conflict of interest is about. I do know that a lot of attorneys secure media rights for their clients. If that could be part of his compensation, I don't know that that's a conflict because he's still going to want to win the case, right? So, let me see if I can find the papers while we're here. We're waiting.
Case number 2020-2603, State of Florida versus Sarah Boone, announcing names for the record beginning with the state.
Chief Catch-Story on behalf of the state, William J. for the state.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah. Have it back.
Ms. Boone, raise your right hand to be sworn, please. Do you swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you.
Good morning, ma'am. Could you state your name and date of birth for the record for me?
Sarah Boone, 10-10-77.
Miss
Ms. Boone is seated at counsel's table, buttressed by her attorneys, wearing a black suit and pink blouse. All members of our jury are present this morning. State, or is there anything we need to address before we bring in our panel? Defense, anything we need to address?
Yes, Judge, I intend to introduce these two exhibits that have already been stipulated to. One is, you did a walking course or anything?
Correct. Right now, your ID is AD as in the and EC as in.
Defense gets identification AB, Judge, which is the order dated June 16th, 2019. It's a no contact order. And then identification.
Can't hear him because he has no mic, but he's introducing those, he's having those restraining orders marked that they talked about yesterday at the end of day. They were restraining orders that Sarah had against George that are going to go into evidence.
Into evidence, and then I'd like to hand publish them to the jury.
Okay.
And let them look at them one at a time. And then I believe we're going to rest our case, but at some point, I guess you would excuse the jury because Sarah Boone needs to be questioned about.
And there may be additional motions to be addressed at that time. So yes.
Do we want to do that now before we're ready to adjourn?
I don't have a problem with that. If you want to rest now, subject to those being entered and published, and we can address any motions. The court has reviewed both of the no contact orders. And that way we don't have to do a in and out. And I can colloquy Ms. Boone at that point in time, and we can proceed with the state's rebuttal case.
Subject to those, the introduction of those two exhibits just mentioned, the defense would be resting our case at that juncture.
Okay, all right. Yes, ma'am. Okay, I've been advised by the courtroom deputy that juror wearing badge 130, seat 10, cannot stay past 5:30 today. So
Like, yes.
just be advised. We'll use our time accordingly.
Yes.
That was the 6th.
I don't believe so. Give me a moment. I can check. That is an alternate. It's alternate in seat 4.
Thank you.
Defense, do you have any motions?
Just out of abundance of caution, I would renew our motion for judgment of acquittal. Defense resting. I'm going to do that now while the jury is still out. I don't have any additional arguments other than what was made the other day.
Okay, thank you. Any other additional argument, Mr. J?
Just that at this point in time, the standard is whether or not a reasonable trier of fact could find the defendant guilty.
and there is sufficient evidence for that to be sent to the jury.
Tonight.
Thank you. The court recalls the arguments that were made after the conclusion of the state's case, both from the state and the defense. The court finds that a reasonable juror could make a finding of guilt on the elements of the sole charge and the information beyond and to the exclusion of each and every reasonable doubt. For those reasons, the renewed judgment of acquittal is denied. Ms. Boone, I have a couple of questions to go over with you, ma'am. You've been previously sworn this morning. Your attorney has indicated that all of the evidence and testimony of all witnesses in your case have been presented to the jury, with the exception of the two no contact orders pre-marked as AB from June 16, 2019, and the no contact order of June 19, 2019, pre-marked as AC, which once the jury comes back in, he will enter into evidence and produce them to the jury for their viewing. Are there any witnesses that you wanted to call that your attorney failed to call?
No.
Is there any evidence that you wanted your attorney to present that any of them failed to present?
No.
Are you satisfied with all of your attorneys up and until this point?
Very.
Is there anything that you would like to bring to my attention at this time?
No, Your Honor.
Okay, all right. I did receive the proposed jury instructions this morning. I'll look at them during the lunch hour, and after the state concludes their rebuttal case, we can proceed with addressing those. Mr. Beck, yes, sir.
The defense did not receive the red line copies that the court discussed yesterday. I don't know if those were sent or not.
I emailed Ms. Barrios last night. Once we got out of court, I'll send them to everyone this morning. Just give me a moment and I'll get those out right now.
That is a good question. Rainy Day. Rainy Day says, why were Sarah's comments to her neighbor not allowed in hearsay, but Jen McCabe was allowed to testify as to what Karen told her? Because one exception to the hearsay rule is statement against interest.
Is there anyone else? The email correspondence that I have is Mr. Owens' email.
Statement against interest made by the defendant. So I did it is a statement against interest. And the comments to her neighbor about how her injuries occurred in Sarah's case were not a statement against interest, and so that's why there's no exception to the hearsay rule there.
Ms. Andrews' email, Mr. Cacciatore's email. Is there anyone else that they need to be sent to from the defense side?
We'll pass them around.
Okay, all right, very good.
Thanks, Barbara. Thanks, Justice is Truth. So happy to be a cupcake. You rock with legal. Thank you. Denise, thanks for gifting. Cover that one. Thanks, Justice is Truth, for the super chat. And for telling people to hit the like button. Helps the algorithm.
All right. Can we go ahead and bring in our panel? State.
Yes, Your Honor.
Defense?
Yes.
All right, let's stand and bring in our panel, please.
Misha wants to know, do you think she's going home after this? I don't think so. I don't think so. Oh, I want to make a correction from yesterday. My favorite witness in the afternoon. I misnamed her. I called her Beryl. Her name is Pearl. When she was spelling it, I couldn't hear it. Anyway, she was awesome. We're in day 5. Today's day 5, right? Oh,
State, you recognize our jury.
Yes, Your Honor.
Defense, you recognize our jury.
Yes, I do.
All right, thank you. Y'all can be seated. Good morning, members of the jury. Welcome back to 12 Alpha in the Orange County Courthouse. If you could, just raise your hands to confirm that you complied with the court's instructions last night during the break. I thank you. Record will reflect that all jurors have raised their hands. We're going to have a little bit of additional evidence presented by the defense this morning, and then we'll go from there. Okay? All right. Thank you very much. Mr. Owens, you may proceed, sir.
Judge, at this time, I would move to introduce defense identification exhibit AB and evidence.
No objection to AB or AC.
What was pre-marked as defense AB will be received into evidence without objection as defense 19. And if you could just identify AC for the record, sir.
Judge, at this time, I would like to move defense identification AC into evidence.
Hearing no objection from the state, what was pre-marked as defense AC will be received into evidence without objection as defense 20.
I mean, Pearl, there wasn't a lot more she could say, Robbie, right? That would be relevant.
And Judge, I would like to publish these to the jury and allow them to take their time and pass these down to.
You may proceed.
We will know about lesser included when they read the jury instructions to the jury at the end, and the judge goes through the verdict slip with them. And I don't know when they're going to have the charge conference, but if they have the charge conference, we may see it before it goes to the jury. Justice is truth. Says, in my opinion, time served, 5 years, and the trail of abuse. Thank you, Justice is truth. Again, for another super sticker. Super chat. Jam Cracker gifting a membership. Thank you. Thank you, Jam Cracker. Carly Gregg retrial has been denied. Well, that's expected. It's going to go up on appeal. You have to make the motion in the trial court first before you can appeal it. So that's pretty standard. Suzanne gifted a membership. Look at that. Jam Cracker gifted 3. 1, 2, 3. Thanks, you guys. Thanks, Suzanne. Justice is truth. It says, good for Sarah Boone fighting for her life, like Karen Reed. Thanks. Life on Makeup says, I saw a Court TV community post regarding the denial of Carly Gregg's motion for a new trial. I read the comments and was in tears. She's just a child. People are disgustingly cruel. I know. I see it every day. I see it every day. Not here because we don't play that game, but in a lot of other places on the YouTubes. Thanks, Poco, for thanking me for my hard work. Thank you for watching. She has a girlfriend who sits behind her in court. I've learned through you and the internet. But I imagine that her girlfriend is not in jail, because if her girlfriend was in jail, she wouldn't be there. So I don't know where. Maybe she got a pen pal. I don't know. Yeah, the closed captions are great, right? That's where we got Motions in Lemonade from. I forget what trial that was, but ever since then, we call the Motions in Lemonade, the Motions in Lemonade. JN Books is speculating, honestly, because the jury has no clue, or shouldn't, about her lawyer count. Oh, her lawyer count, right? How many lawyers she's had, and the letters, along with other shenanigans. We're going to have a hung jury. I don't know. I'm glad I'm not on this jury, because I think this is a harder case, a much harder case to decide than I thought initially going into it. Mal says if she didn't have the video of him in the suitcase, she would have had a better chance of going home. I personally doubt it. It's going to be hard to get past that video. And they can watch it as long as, as many times as they want to back there. A lot of people think hung jury. Thank you, Julie Murphy. A lot of people would say differently that I have empathy and kindness while maintaining objectivity. Some cases I get very passionately involved in and have a very strong opinion about. This one, I'm a little more objective, I think. Thank you. Time for Pop-Tarts and time for her Pop-Tarts for a boyfriend now. Sandra. Karen Reed was framed and lied about. Sarah Boone has created the fictitious storyline with no facts. Nobody to present George's side who is credible. No comparison between Sandra Boone and Karen Reed, in my opinion. Depraved heart, yeah. Depraved heart. Jam Cracker's opinion has been swayed. Yeah, the repeated in her interrogation. It wasn't intentional. It wasn't intentional. It wasn't intentional. Personally, I don't think it was intentional. I think she's a drunk. I think she's an alcoholic. I think she's got she's an alcoholic. She's a raging alcoholic is what I think. And I think she probably had a blackout. And most of when she was videotaping him in the suitcase, she may have been in a blackout then. I don't know. I don't think she meant for him to die. Did it show a depraved heart? Would a reasonable person think that somebody would die in a suitcase and wouldn't be able to unzip it from the outside? It's a very complicated question for me. But, stupidity is no excuse and being drunk is no excuse. So you don't get that. You don't get a diminished capacity defense by saying, well, I was so drunk, I didn't know what I was doing. That doesn't.
Mr. Owens, any other additional witnesses, evidence, or testimony, sir?
No, sir, on behalf of Sarah Boone, the defense rep.
Thank you. State, are you intending on putting on a rebuttal case?
Yes, Your Honor.
You may proceed, sir.
Speak with Dr. Tanya Warner.
Okay, we're in rebuttal now. Something is so funny, Auntie Bev says, Sarah told forensic psychologist, I made a big deal about that yesterday, that she was mad, not terrified, and no mention of any overt act. Game over. Well, the judge did find an overt act as a meaning of law by him sticking his hand out the suitcase, and that is why he allowed all this other evidence in. Imagine if he didn't, none of that stuff would have came in. About the prior acts of DV, about the choke marks to her neck, the photos of her injuries, none of that would come in. It would have been an easier case if that stuff didn't come in, I
Dr.
think.
Good morning. Could you state and spell your name for the record for us?
My name is Tonya, Tonia, Warner, W-E-R, N-E-R.
All right, thank you. You may be seated, ma'am.
Thank you.
Good morning, ma'am.
Good morning.
Where do you work?
I'm employed at Meridian Behavioral Health Care in Gainesville, Florida.
And what services do you render there?
I'm their chief medical officer.
And can you tell the jury what your educational background is?
Yes. So I graduated with an undergraduate degree at the University of South Florida in chemistry. I then attended medical school at American University of the Caribbean. I did a residency in psychiatry at Connecticut Valley Hospital in Connecticut under the auspices of Yale University. I then came back to Florida and did a fellowship 1 year in forensic psychiatry at the University of Florida.
And since your educational background, what have you been doing professionally?
Yes. So I'm a licensed physician in Florida. I am board certified in general psychiatry and forensic psychiatry. I was initially employed on faculty at the University of Florida from 1998 through 2015. I retired there.
That's why he did it. Yesterday's doctor, this expert for the defense, was a forensic psychologist. This is a forensic psychiatrist. He's going to make a big, in my opinion, he's going to make the jury think that her opinion's worth more because she's a psychiatrist.
as the vice chairman of the Department of Psychiatry and the director of the Forensic Institute. I then went to work as the chief medical officer at Meridian Behavioral Health Care, which is a community mental health center.
What is psychiatry?
So psychiatry is the treatment of mental health disorders.
And what is forensic psychiatry?
Forensic psychiatry is the interplay of psychiatry and the law. So anywhere where psychiatry intersects with legal issues.
What is the difference, if any, between a psychiatrist and a psychologist?
So a psychiatrist has gone to medical school, where a psychologist has not.
And as a licensed physician, are you able to prescribe medication?
Yes, I am.
In the course of practicing medicine as a psychiatrist, do psychiatrists prescribe medication to treat mental disorders?
Yes, we do.
Congratulations,
And
Linda.
when did you
Congratulations
begin-
on being sober since 1995. That is huge. Okay, so a psychiatrist goes to medical school. Psychologist doesn't, but they need a master's, right?
Your work as a forensic psychiatrist as opposed to working at the faculty at the University of Florida, or was that concurrent?
It's up to a jury. To
In
decide.
1996, in the state of Connecticut, while I was doing my training at Yale University, I testified for the first time as an expert witness in the state of Connecticut.
And over the course of your career, have you done forensic psychiatric evaluations?
I have
Approximately how many?
thousands of times.
And does this include on matters such as competence?
Yes, it does.
And does it, just explain briefly to the jury, what does that mean, legal competence?
So competence is, do they understand the legal process? Do they understand who the different players are in the courtroom, who's on their side, who's not on their side, what they're charged with, what the possible penalties are, what the possible plea options are?
And have you ever done any forensic evaluations about insanity?
I have. I've done sanity at the time of the crime, and also I've been appointed by the governor of the state of Florida to do sanity for execution.
And have you ever been involved in working as a forensic psychiatrist involving the subject matter of battered spouse syndrome?
I have.
Can you describe your experience in that area for the jury?
I've been asked to do evaluations by the prosecution and defense several times with regards to, and it's come up in different cases, criminal cases with regards to intimate partner violence.
And does all violent episodes within a relationship result in something that we are describing as battered spouse syndrome?
No.
And I see there is a book in front of you. What book is in front of you?
Yes. So this is the Diagnostic Statistical Manual, and this is the 5th edition text revision, which is the most current edition.
Is battered spouse syndrome in there as a diagnosis?
No, it is not.
And where, if anywhere, does it fit?
Where, if
into any of
anywhere?
The categories within the DSM-5 TR?
It would come under one of the trauma categories, most specifically under most likely post-traumatic stress disorder.
Can you describe for the jury what post-traumatic stress disorder is?
So this is a disorder that's recognized under the DSM for individuals who have suffered a traumatic event, and then they have re-experiencing of the traumatic event. They have different symptoms besides re-experiencing, such as hyperarousal, and also avoidance of triggers or symptoms, things that would trigger a response to it.
Are there any agreed upon criteria within the relevant forensic psychiatric and forensic psychological communities about battered spouse syndrome?
There are.
And what would those be?
So it's again, having experienced a trauma, repeatedly, violence within an intimate relationship, and then having symptoms secondary to that, avoidance, so tiptoeing around, trying to avoid recreating the violence.
And if a person experiences an environmental stimuli, something happens to them another person does or says something to them, is their subjective reaction what is defined as whether there's trauma present or not?
I'm not sure I understand the question.
Let me rephrase it.
You can rephrase.
Calls.
You described there's a difference between experiencing a violent relationship and whether or not that person is going to experience trauma from those behaviors they witness and experience. Is that fair?
Yes.
Now I've lost my train of thought.
Hate when that happens. Happens to me all the
Is it fair
time.
to say that an experience that a person has, whether or not that person believes it's traumatic, is a subjective experience?
Yes, each individual is different. And so each individual is going to take that experience differently.
Can hypothetically a couple be involved in a violent relationship for a number of years, even 3.5 years, and battered spouse syndrome not necessarily apply to either or both of them?
Yes, that's correct.
Can you explain that?
So again, each individual is different. So one individual may develop the symptoms of battered spouse syndrome, and one individual may not under the same exact circumstances, just depending on their makeup and what they've experienced in their background and their biological makeup.
And is there a cycle of violence that is sometimes used to describe battered spouse syndrome?
There is.
Can you describe that?
There is. So there's the initial, there's kind of a tension buildup section where you feel the kind of tension building up, and the individual can feel kind of the incident coming, and then there's the actual incident of violence. And then following the incident of violence, there's a honeymoon phase, what they call the honeymoon phase. And that's the third phase, where the individual who created the violence attempts to make up to the victim and recreate kind of the relationship and pull them back in. And then it starts all over again, where you feel the kind of tension start building up again to the incidents of violence.
Does abuse have to come in the form of physical or sexual violence?
No.
Can you explain your answer?
So it can also come in ways of coercion. It can come in ways of control, such as financial. So if an individual controls another individual financially, or controls their ability to drive or go out, their ability to be around their other family members or friends, kind of isolates them from other individuals, controls their ability to work, so controls their ability to make money or access the funds, so they can control them in any number of ways.
Thanks,
Is
Kelly.
this kind of about like an inequitable power dynamic in the relationship?
Yes, absolutely.
Can a man be on the receiving end of emotional or physical or sexual trauma and potentially experience, strike that. Can a man be on the receiving end of verbal, harsh words, physical violence, or sexual violence and end up having the syndrome of battered spouse syndrome?
Yes, it crosses all boundaries, and we see it in all types of relationships, whether it be heterosexual or homosexual relationships. We see it cross all boundaries.
And
We saw him smash the
does this
TV.
element of control come from
yesterday.
controlling personal items such as identification papers?
Yes, absolutely.
Can control potentially, hypothetically, come from partner A gifting partner B an item, but still considering that item partner A's because he or she paid for it, even though it was a gift?
Yes.
And in this particular case, were you asked to do an evaluation of Sarah Boone?
Yes,
Do you see Ms. Boone in courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's sitting at a table there, wearing a dark suit and a pinkish top.
Did the record reflect she's identified the defendant?
Record will so reflect.
What date did you have an evaluation of Ms. Boone?
It was early in October, I believe October 2nd.
And this was at the request of the state of Florida
Yes, it was.
and subject to a court order?
Yes.
And who was present for this evaluation?
The defense and the prosecution.
All right. Tell us about the evaluation with Ms. Boone. What do you do first?
So I met with Ms. Boone at the jail in a conference room. Again, the prosecution was there and her attorney. I met with her for approximately 2.5 hours, just under 2.5 hours. I introduced myself and explained that the interview would not be confidential, that I would be coming to court if asked to share my opinions. And she agreed to participate. I then start out with just general information, so getting to know her, date of birth, kind of background information, who her parents are, childhood. I go through her educational background, her work background, her marital background. I go through health, psychiatric background, any substance use issues. I do a mental status examination.
Can I stop you there?
Yep.
Elaborate further on that.
So a mental status examination is just questions to determine kind of memory and cognition, kind of how their thought process is, how they're thinking. Are they able to kind of fluidly think through processes?
All right, go on after that.
And then I transition from there into walking through the incident that happened with her.
All right, what did she indicate occurred on February 23rd, 2020 to you?
All right. Is it all right if I refer to my notes just to?
Just if you need them to refresh your memory, please do so, but don't read from them. Just let us know.
So she had a difficult time recalling what time they actually woke up that day. Initially, she said in the morning, and then she said she wasn't even sure that it was in the morning. She said that they both wanted to drink, but that she asked that they could clean the house first instead, and that they did some vacuuming and cleaning. They had a
She's, Sarah's furiously writing notes right now. She said we both wanted to drink. He was the one who wanted to drink. It wasn't me. I wanted to do chores and finger painting and puzzles.
half a bottle of wine left over from the day before that they drank. She felt about 4 o'clock in the afternoon. They drank that out on the back porch. And she described that they had kind of 2 beach chairs out there and a dartboard, and that they kind of hung out there a lot on the back porch, spent time out there. They did a puzzle out there and completed that, and then did some kind of artwork. She felt like he was getting frustrated thinking about his life, that he had lost his job. And so she encouraged him to call his daughters, although she knew that that they did not like to talk to him when he was drinking. So I'm not sure why she had encouraged him to call them at that point, because they were already drinking. And she also at some point encouraged him to call his brother, because she wanted him to explain to his brother that he had pulled her down the stairs the night before, although that didn't happen. He didn't explain that to the brother. And according to her. And then at some point they went and got another bottle of wine and some cigarettes from the grocery store.
12:15.
And continued to drink. And then they were inside the house, and then he tagged her at some point and said, "Tag, you're it," which indicated that they were going to play hide and seek. And she said she went upstairs and hid in the shower and waited for him to come, and he never came upstairs. Excuse me. And so she eventually came out of the shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it.
Wait, she said that he slipped into the suitcase? Hold on a second. She's getting some of the basic facts wrong here, which I don't think is good. She says that they started drinking their half a bottle of wine at 4 p.m. and at some point they went and got another bottle. Like they bought the other bottle at 12. We've seen all of the video, so we know the facts better than she does. So I don't know how this is going to go over with the jury or if they'll even notice.
Came out of the shower to look for him. And as she was coming down the stairs, she said she saw him slipping into a suitcase, which was on the living room floor, that they had put out because they were going to donate it. And sorry. And so she went downstairs and indicated that she had found him, and they were kind of laughing. And she zipped the suitcase up. And they continued to laugh, she said, at that point. And they were having a good time and laughing and enjoying themselves and having a good time. And she said, and then she became angry. And she said she remembered what it felt like when he was choking her. And she became angry.
What did she do after she became angry?
I'm going to refer to my notes at this point.
If you refresh your memory, just
Yes.
put them down and then tell us what you remember.
Suitcase and okay. She said that she shook the suitcase and that she lost control of it and it flipped.
And then what happened?
Then she said that he stuck 2 fingers out and her son's baseball bat was sitting there and she picked the bat up and hit his hand.
Then what happened?
And then she went upstairs and waited for him to come upstairs.
All right. Alcohol. Can you tell us what you know about the effects as a medical doctor of ethanol or alcohol on a human body?
Yes. So it causes intoxication, as we all know, and it causes disinhibition. It works on the frontal lobe of the brain and allows us to do things that we wouldn't normally do. It disinhibits us.
And in the course of your practice, have you ever come across a diagnosis of alcohol abuse disorder?
Yes.
And what is that?
Well, alcohol abuse is an old disorder. So we used to use alcohol dependence and alcohol abuse. It's now been combined in the DSM-5. In the DSM-5 TR, it's alcohol use disorder.
In considering what a patient or a client or somebody that you've been asked to evaluate by a government entity, do you take into account that person who's relaying the history to use a consumption of alcohol at the time of the history that they're given?
Yes.
Why is that?
Because again, it affects their behavior and their actions.
Does alcohol have any effect on a person's memory?
It can.
What, if any, relationship is there between acute alcohol use or acute alcohol intoxication and battered spouse syndrome?
Again, it can affect your memory. It can affect your reactions. It can affect your response to different things.
Does the disinhibitory nature of alcohol strengthen, weaken, or have no effect on battered spouse syndrome?
It would depend on each individual again.
Generally speaking,
I
it's
disagree with the
important
drunk
as an
driving
evaluator
analogy,
to
Peter,
get-
that you keep putting in the chat, and I'm just going to tell you why. Because when you drive drunk, that's a choice to get in front of behind the wheel of an automobile. That's a dangerous instrumentality under the law. This is completely different. I just can't get on board with that analogy for many reasons. This is a whole different thing.
Get as much information as possible before rendering an opinion, such as diagnosing somebody with something out of the DSM-5 TR or battered spouse syndrome.
Yes.
In this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening?
I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
And what was your opinion?
My opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
And specifically talking about,
People could work.
Yes.
Well, again, she only met with him for 2.5 hours. I mean, she only met with her for 2.5 hours. The psychologist yesterday met with her 9 different times. Thank you, Stuart, for your compliment. Also, with regard to drunk driving, we have specific laws against drunk driving. There's no law that says you can't get drunk in your own home and play hide and go seek. So there is a distinct difference there as well. Are we behind? We're a little bit behind. Let's just FF it a little bit. Also, there's no self-defense. There would be no self-defense claim in a drunk driving case either. I don't know, Della. She testified about the TV, but I don't remember what she said. He said, "You're going to help me take this TV out. You're going to help me take this out." Was that to the street garbage? Was it already broken? I don't know. If anybody remembers exactly what she testified about the broken TV, that was when I had to leave and I lost service for a few minutes and I didn't hear that part of it. Happy birthday, Femme Dandy. Happy birthday. 35. Happy birthday. Enjoy it. Enjoy the years. Just me says, if everything Sarah said is true, she would have been able to get a permanent restraining order. In my opinion. It's Florida. Florida people, if you're in the chat, chime in about restraining orders and how hard they are to get. She also kept letting him back. So she let him violate the orders. I'd be interested to see what the actual orders say. Be of good cheer thinks that the smashing the TV was another one of their Sunday fun day activities. Summer makes a good point. If George's family has a history of abuse, she was probably afraid to get a restraining order or file charges with fear that his family might come after her. She knows the family history. Yes, and remember, she did say during much of that body cam footage that, his family's going to kill me if they find out. What are you going to tell? She was very nervous about what they were going to tell George's family about how he died. Very, very. Kelly, thanks for that article. I'm going to take a look at it now. She was very nervous, and she said that the family was going to kill her. They always hated her. They called her the white blue-eyed devil or the white blue-eyed dragon. She had 2 different nicknames that they called her. All right, so it appears that George's brother, he was arrested. Was he ever convicted? Oh, this was in May. This was just in May of this year of 2024. In Castleberry, Florida, a man has been arrested after he allegedly stabbed his girlfriend in the head on Wednesday. This was in May. Police have identified the woman, 34-year-old Vanessa Marie Santiago. She was a mother and shared a child with 37-year-old Pharrell Torres, the man accused of killing her. Yikes. says that he, Torres, called 911 himself Wednesday. He reportedly told the dispatcher that he stabbed his girlfriend. When police arrived, they found Santiago stabbed in the head. Yeah, I was wondering about that too. Now that the character evidence is allowed in, why is nobody coming out and saying he was such a great guy? He never would hurt anybody. I don't know. Thanks, Kelly, for sharing that. Jury's not going to hear about it. And it happened in 2024, which was after this incident, which happened in 2020. Hi, Becca. Yeah, I have it up here. It's not a brief, it's a motion. State made a motion saying it's a state's request for in-camera hearing regarding financial arrangements between the defendant and the defense team. It says the defendant is indigent. She has had several appointed lawyers prior to forfeiting her right to an appointed attorney. The defendant is receiving costs money from JAC because of her indigency. Apparently, only investigator Billy Lane is being paid with JAC money. The defendant has secured the services of 4 attorneys and a jury/trial consultant, and perhaps more people that the state is unaware of at this time. The defense team is expending a tremendous amount of costs, having traveled from Milton, Florida to Orlando, Florida for a several-week trial. The team returned to Milton, Florida prior to the arrival of Hurricane Milton in Central Florida and then traveled back after it had passed, incurring additional costs. The state is concerned about a potential conflict of interest between the defendant and her team. The only way for the court to know if there is an actual conflict of interest rather than a potential conflict of interest is to review the financial agreements between the defendant and her team. If there is an actual conflict, the defendant can waive this right with clear, unequivocal, and unambiguous language. And then it says, citing a case for a waiver to be valid, the record must show that the defendant was aware of the conflict of interest. I thought it was frozen, but it's just the witness who's like a statue. I can see the court reporter's head moving. That the defendant realized the conflict could affect the defense, and the defendants knew of the right to obtain other counsel. The state is requesting the court to conduct an in-camera examination of the financial arrangement to assure there's no actual conflict of interest, and if there is an actual conflict of interest, the defendant validly waives any actual conflict of interest. They just want to tighten it all up and make sure that there are no appellate issues. She can't come back later and say, they don't say exactly what the conflict is. I must have read something somewhere else that said that they may have secured media rights to her story, and that's how they're being paid. But it's a good idea to get it on the record. An in-camera review just means that a judge would look at that in chambers, outside courtrooms. What does JAC? I don't know. It must be the Florida. Hold on.
Members of the jury, thank you so much for your patience. I have a matter I have to discuss with counsel outside of y'all's presence. It may take a little bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting for us to figure out what we're going to do next. So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research as to the person, places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things, and we'll bring you back in as promptly as possible. Thank you.
Okay, so the JAC in Florida is the Justice Administrative Commission, which is the state agency that provides administrative services, and they provide court-appointed counsel. They pay the bills to court-appointed counsel and the costs associated with the defense for experts and such things as like that. Thanks for asking. Look how much we're learning today about Florida's system.
Y'all can be seated.
Is it Milton, Florida, and Hurricane Milton?
Mr. Owens, if you can find me that portion of the transcript that we were addressing as to additional opinions and other depositions and anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Well, and Judge, it applied to every every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38.
Okay, I'm just going to ask that if you're watching something somewhere else, and if there's any other breaking news, please do not put it in the chat because it's distracting and it also redirects people away. So I just ask that you please don't do that.
When she started talking about a generalized anxiety disorder and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits and that those were my two major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder, and that I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38.
38, line 21. I need time to go through my notes, think about it, process it. But I had the other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process all my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7th for jury selection. Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches. And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward, and then you can add to your deposition at that point if my opinions change after having reviewed further. Then I refer to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Then I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41
Okay.
that addresses specifically opinions
Let me go back.
as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more. Because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission, but she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge, to being in the correctional setting right now. And that the stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to depose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Werner says absolutely. And then, do you want me to continue reading or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question, That's how she answered. She goes through a little bit of that. And then paraphrasing, she talks about the grandiose component of criteria that she met. And then on page 45, I asked her what other criteria, on line 1, would tend to indicate that she was a narcissist. And the answer by Dr. Werner, I didn't say that she was. I said that she has narcissistic traits. And that was the examples. That was.
Excuse me for interrupting, but can we lasso this back in?
I understand that's what the depot reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. At this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or diagnosis of narcissism. The question pertains to PTSD.
All right, page 46. Line 1, question, okay. Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail and harm her. She talked about that. And she spoke about, having recollections, remembering abuse from George during the evaluation. Question 13, line 13 on 46. But you don't believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15, no. I would have to look back through my notes to see if she fully met the criteria. Question, line 17. Can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19. No, I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question. Is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer, I may. Number 25, question. Okay, and that's something you will let the lawyers know about if that changes? Answer, line 2 of page 47, yes. specific to the post-traumatic stress disorder.
Okay.
So at the time of this deposition, when I asked her specifically,
So what's the legal objection? What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
What
I
are the
will be notified of
what are the
any changes.
legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection?
Facts not
I
in
understand the
evidence.
backdrop.
I mean, I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of a change of opinion and I would be allowed to take a second deposition. That's the only thing I know to object to.
Okay.
Because I was not given that opportunity, which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making. What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no. And I asked, well, then my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing. And once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened. I'm not asking her about her diagnosis of PTSD. I'm not going to be going
agree.
into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety. Because my understanding of what she told me was that none of this matters. None of this matters because of what she said to us during.
Okay, then she should not be able to render an opinion that Sarah has PTSD because she said during the deposition she couldn't make that determination. So the defense attorney is right here. We'll see what the judge does. Ms. Jessica says it's not fair. A legal argument. That's hilarious.
During the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And my expected answer was, it doesn't matter because of what she said during the.
Well, then she can't
Okay.
opine that she has.
Unfortunately, that was not the answer that came from the witness.
Right.
The answer was a
But that's not
definitive no.
the attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said. Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert.
I love
But
Cape
that
Cod.
doesn't mean that that's my opinion, that post-traumatic stress does not
Okay,
apply.
that's irrelevant for the purposes of this argument.
Well, their discussions and him feeling like it didn't apply.
Okay, as an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed. And the opinion that was offered at the deposition was, I'm not sure.
Right.
And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given. So what is it that you're asking me to do at this time, Mr. Owens?
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
What if any?
Ms. Crawford?
Yes.
All right, you've been present for all this hearing, yes, doctor?
Yes.
Am I misrepresenting any of our conversations?
No.
And so If I ask you if battered spouse syndrome or PTSD has any relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
Okay. And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No,
And if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening?
no.
That's it.
Judge, number one, she's given a legal opinion. Number two, it's a discovery violation.
What is the legal opinion?
The post-traumatic stress disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
I would like to have known that, and that was going to be her opinion before today.
He is a little
That's
bit
not
whiny.
changing testimony.
Billy?
Where is that a change in the
So you're
deposition?
going to have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it and find where I asked her.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. And the state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this in her deposition when we had that hearing. So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66, line 20.
Sounds that way.
Let me know when you're there, Judge.
Hang on. Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1, yes, sir. Question. Then I go into fees.
Welcome, Amanda and
Then on 67,
Amelia?
line 7, question, just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer, that I've been asked about. If I'm asked something else, that I'll offer it. Number 12, question, and you've been provided all the resources you need to rely on and express your opinions. Line 14, answer, I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion. I believe it's a discovery violation because I should have been notified there was going to be a change in opinions here today. And we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of the trial.
ambushed. Attorneys love that word.
What new opinions are different based on what Mr. J proffered the testimony is going to be?
I have to ask Madam Clerk to reread the question and the answer from the expert. It's been so long now.
Madam Clerk, or Madam Court Reporter, are you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely.
Mo, thanks for your super sticker. Madam Court Reporter gets a moment on television. Yay, Madam Court Reporter. Lori Fossa, thank you for your $10 super sticker. Appreciate you. Justice for Truth has a lot to say. Thanks for all these super stickers. For those of you that have never suffered abuse, please open your mind to the trauma that occurs. It's real, it's painful, it affects every moment of every day of your life. Please be empathetic. Thank you for speaking from experience, and I'm very sorry that happened to you. She also says, don't judge someone that uses alcohol to numb themselves. Sometimes the pain is so deep. I understand that, been there, done that. It's bad, but it's real. So sorry. I think you'll find a lot of like-minded folks in the chat. Kelly says, I live local. His family hasn't spoken.
Court's going to step off for a moment while Madam Court Reporter is able to provide that reading.
Okay. I'm going to mute them so I can talk to you. Kelly says, I'm local. His family hasn't spoke because they have all been in and out of jail for DV. His brother is currently in jail for the DV death of his girlfriend. And that's the article that you just sent me that we read. He stabbed her in the head tragically. Thanks, Kelly, for being our local boots on the ground. Justice's Truth is back and says, I'm so passionate after hearing the testimony that Sarah was abused, had no support systems, and turned to alcohol to numb her pain. George was an abuser. Alcohol was an issue, not intentional. So sad. I wonder, though, Justice for Truth, and I don't know that we've heard any testimony about this, about whether Sarah was an alcoholic before she got with George. She'd only been with George for about 3.5 years. And we didn't hear a whole lot from her husband. I'm wondering if they're going to call her ex-husband, Brian. I wonder if they're going to call him back because now he can testify about whether she was prior violent with him during her marriage. And I think some people in the chat have pointed out that he did say that she was violent towards him when she was drinking. So she may have already been an alcoholic. She may not have turned to drinking when it had to do with George. But so I just want to see if we get any clarity on that. And then she says, please know abused people are living in a state of terror all the time. I've been abused and I understand that. You do whatever you can to survive. I'm so sorry. I truly hope that you were able to get out of your situation and I wish you all the strength. And because of that, and you mentioned that, I'm going to put the DV hotline number scrolling along the bottom until we get back to this witness. And if anybody needs this number, please call 1-800-799-SAFE, 1-800-799-7233. When all of you share your personal experiences, it really helps a lot of people in the chat who are going through it. Whether you think that Sarah was abused or not, whether you think she was the aggressor or not, there are a lot of people here in the chat who are willing to talk about their own experiences and to help others who need advice. Yesterday, we had a woman in the chat whose daughter was in a DV relationship. And she said, I don't know what to do. I don't know what to do for my daughter. She won't leave. She won't listen to me. And so many of you had such kind words and such great advice for her who have been there. Chelsea, thanks for hanging in for 4 months. I'm genuinely curious about opinions to overlook that she was abusive also. Is it gender? He was awful, clearly, but by all accounts, so was she. I agree. I think men can also be abused. We have male victims in the chat as well, and they talk about their experiences too. Lana, thank you so much for tuning in from down under. Two things can be true at once. You can feel bad for her for the toxic relationships she was in and the abuse she suffered, and condemn her for being so intentionally reckless with human life. 100%. 100%. She could have been a victim of DV. She could have been a victim and an aggressor of DV. She could have been, and she could have intended to kill him. She could have had a depraved heart. That's why this is a very, very difficult case, in my opinion. I love you back. Thank you, Lana. Tanny, I have a question. Sarah maintains this wasn't intentional. If she's claiming battered spouse syndrome / self-defense, does that not imply an element of intentionality and that she was justified in taking the action? It does. That's why the jury instruction on using battered spouse as a self-defense is going to be so important here. So that's why we need to wait and see what the exact Florida jury instruction is on this. Because she has to show an overt act in order to get all of this evidence in. And then we're waiting to see what the actual jury instruction is with regard to battered spouse. And my impression of it was that there had to have been intentionality. She intended to defend herself, right? Usually jury instructions are so boring, but in this case, they're going to be so important. Justice is truth. Thanks for another 20. Abuse is very traumatizing, and most people, generally women, do not leave, especially when they have no support systems. Many times they end up injured or dead. Her ex was an enabler, not a support. She had no one else. Thank you. Thank you for sharing your personal experiences. And she also says, I am not happy that the perspective, you mean the prosecution, is twisting truth. I know they have a job, but they're also supposed to find out truth, not their desire to win. Yeah, we say that. A lot of times they're looking for a conviction, not justice. Thank you. And then she says, I'm not an attorney, but I am a nurse, an RN, and I understand abuse. It was clear abuse here, but alcohol played a part. As far as I'm concerned, time served. Thank you. David Reese coming in with a deuce. Your Honor, I must strenuously object. I object because it really sucks for my case. Thank you, Jeannie, for the really generous $50 $50 cash app, who says, you're my first and only membership. Oh, Jeannie, I love you. Chickens to crochet. Thanks for the 5. Alcohol can give a victim of DV the courage to do things they would never do otherwise, and they end up regretting in one way or another. Yeah, this is a tragic case all around. Rest in peace, Jorge Torres Jr. Oh, and then Jeannie came back again and said that I'm the bee's knees. Oh, pregnant pause. That's your username, pregnant pause. Yeah, I love that. If you do choose to send Cash App or Venmo, which is an amazing way to support because YouTube takes a third of all super chats, I'll always read your question unless you say anon, please, at the beginning of your comment. Put anon, please, like Dumois, if you know, you know. Anybody know about Dumois? And Christina, thank you so much for your Cash App, because a lot of people like to remain anonymous, especially throughout the Karen Reed case and others. And I totally understand that. Dumois. Anon, please. We are right now on break because the court reporter needs to read back some testimony, and she's looking at her. She's scrolling back through the testimony. Oh, yes. Thank you. Thank you. Thank you. Yep. Hall of Fame, baby. Hall of Fame. Mrs. Bucket says, I also think time served is enough. Anne's like, if you're playing games with your lover, play checkers. Yeah, darts. I didn't think darts was a good idea for them. Debacle Watchers is the video with Brian shows alcohol was used heavily prior to George, right? We didn't see that video. They haven't shown it. They may show it on rebuttal. I'd like to see it. He testified. Like your mom says, I really hope they recall Brian to the stand and get some good tea. Jennifer says, my mother was a court stenographer. She dreaded readbacks. I know. Patty misses Madam Court Reporter from the Reed trial. Oh, that athletic cup that she would speak into was so weird and distracting, wasn't it? No darts, Anne. No darts. For Fox's sake, her life situations led her to unhealthy coping habits, but she is still responsible for her actions. She may have blacked out, but there are consequences. I agree. And there are a lot of things at play here. Heidi, I'm sorry. It says my mom was abused. She became an alcoholic years into it, and while drunk, she was a different person. She would start fights and be aggressive, provoking him. The abuse caused it. I don't know if this applies to Sarah's case. At least one of the doctors has said that. Anonymous Canadian girl. Not all of us who find ourselves in abusive relationships are the same. In fact, my big mouth got me punched more than once. I just couldn't help trying to defend myself. I'm so sorry. I hope you're able to get out. Dee says she should have taken the plea deal. Where did George's brother commit his crime? Anyone? I do. I have that article still up. It was in Castleberry, Florida. Casselberry. Cycle of abuse. Off topic, Heather says, but have you heard, no, they filed a reply brief. Is that what you're talking about in the appeal? Yeah, I have it. And I'm going to read it unless you're talking about a letter. Going to go over that hopefully at some point today. I mean, there's a lot of dead air here. We could be doing it now. I'll go back to this later, but can't really do it. It's a reply brief in the appellate court in the SJC on Karen Reed. Yes. So yes, I have it. Virgin Mick, there was a time in my life I thought the only way out was to end him. I didn't do it because it was wrong. Also, I never abused him, not even verbally. Sorry. That's what it looked like to me, Ann. Did it look like that to anyone else, or was it just me? Cheryl says, my opinion, but she's only saying how abusive George was, but we don't know how abusive she was to him because he's not here to say. Well, I think they're going to bring some of that in on rebuttal. So we are going to see. I think they have body cam footage from some of the incidences where the law enforcement came to the home. So there's that. So Sarah's picks were real. Yeah. Kelly says, I also think part of Sarah's flat personality and look what I can do attitude goes back to the death of her parents and grandparents so young she had to adult. Yeah. Justice is truth coming back in. Wait, why are you cutting off your feed? Law and crime. Says prior to trial, I would have not said time served was enough, but now I agree. I thought this was just an unstable person. Now I understand she was an abused person. Abuse is real. Thank you. Let Justice for Truth know in the chat that she's not alone if you too are a survivor. Because I think you found your people here, Justice for Truth. Thank you so much. Looks like they put that up by accident. Thank you for watching. Chantal says, in my opinion, we are confusing abuse with a toxic, mutually violent relationship. But if it's a mutually violent relationship, doesn't that equal abuse? Right? Isn't an abusive relationship a toxic relationship also? And if it's mutually violent, isn't that also abuse on both sides? Or does abuse only have to be one-sided? See, I don't know. I don't know. Thank you, Chantal, for your comment that I starred earlier. And Mama Buck, who chimed in, I understand there was no one on George's defense, but it could also speak volumes that there's no one stating that he was a good guy. Oh, I think we just went over that, how battered spouse changes to intentional. That was just a trigger warning. Kate says, I think the cycle of abuse in his family should be allowed in. I don't know if they tried to get that in and it didn't come in. Did they? Manifesto says, guilty of manslaughter makes the most sense to me. Haley says, Sarah said the abuse started on the first date. Chelsea B's like, Brian Boone, the white, blue-eyed enabler, says dishonorable Kim Jong Kanone in the house. All right, again, if you guys are watching a different case somewhere else, please just, refrain from putting it in the chat because you're trying to redirect people to go watch something else. And it's just not a cool YouTube thing to do. Thank you. Appreciate that. And I'm not going to switch over to covering something different when I'm covering this right now. So there's that. How is abuse an excuse for murder? Well, it's self-defense. And that's what they're trying to show here. But in my opinion, I don't think they've shown it. If you can show battered spouse syndrome, and in the moment, there was an overt act that made you fear for your life and you had to use deadly force in order to protect yourself, that can be used in Florida as self-defense. I don't know that it applies in this case, But in other cases, it did, like Marsha Thompson, who was recently acquitted of murdering her husband while he slept on the couch because of years and years and years of abuse.
State of Florida versus Sarah Boone. State.
Dave Castro on behalf of the state.
William J. for the state.
Defense.
James Owens, Ms. Boone.
Kevin Beck, on behalf of Ms. Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony?
Yes.
Okay, you may proceed.
It's true. And under battered spouse, the mental abuse can also be considered abuse. What the duck?
By Mr. J, question. You've been present for all of this hearing, yes, doctor? Answer, yes. Question, am I misrepresenting any of our conversations? Answer, no. Question, all right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case and the defendant relayed them to you, what would be your answer? Question, that it's not related to the incident as she reported it. Question, okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question, if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
I don't think that's the very beginning, before I objected.
Yeah, he wants to hear the question before the
What was
objection, not the
asked?
proffer. The question before the objection, before they sent the jury out, the question that was in front of the jury. That's what he wanted. I don't think it was clear.
Was to read back the proffer.
It wasn't clear.
I thought I was asking to go back to the very beginning when the question was asked and then her response and my objection to it.
What was specifically asked was to the proffer, because the question before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that.
Oh my God.
Mr. J has advised the court that's not what he was hoping the answer would be. That the answer was supposed to be something different as identified in the proffer, which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why it did not apply in her opinion. That was not discussed in any way in the deposition.
Okay, my question is specific as to opinions. Her opinions were as to battered spouse syndrome or post-traumatic stress disorder and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them, based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
David makes a great point here, if you can look at your screen.
I think I'd refer to page 46. Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria. Question 17, can you explain why you don't think she suffers from post-traumatic stress disorder? line 19, answer no. I didn't say one way or the other. I would have to look back through my notes for that. Question number 21. Is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? 24. I may. 25. Okay, and that's something you will let the lawyers know about if that changes. That's on page 47. Line 2, yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering an, unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back when it was first going on, when a question was asked, and I believe she rendered an opinion. And I, again, like that to be reread back. What the initial question was, what the response was, because it did. I know I objected. I can't even remember it now. But I know I objected because I knew it was inconsistent with.
You asked to approach, and then you explained that the question was it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some.
Just let him hear the last question that was on the record before you sent the jury out. It's really simple. She's already into the transcript. She can just rewind it a little bit. Just if she's got the little machine with the paper, just go back to the question that was asked before you sent the jury out. That's all. It's very simple. Do we need to make a big meal out of this? Just do it. We're going to roll into lunchtime now.
Legal objection. You know, Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that? So
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter, if you could be so kind. Yes, ma'am.
By Mr. J, question. You've been present for all of this hearing. Yes, doctor? Answer, yes. Question. Am I misrepresenting any of our conversations? Answer, no. Question. All right. So if I ask you about Battered Spouse Syndrome or PTSD.
No, this is the proffer.
The facts of this case as the defendant relayed them to you, what would be your answer? Answer. That it's not related to the incident as she reported it. Question. Okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any of the materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if you could go back to the initial.
Yes, Mirabelle. Yes. Breach, sis. Stop crinkling your damn papers. Mirabelle says alcoholism is a family disease. All experience trauma from it, especially the kids. The addicts, something over decades were dark tornadoes that left a wake of destruction with everyone in their path. Yes. The ripple effects of alcoholism are enormous on the entire family. Murder of a man for his brother's crime is not acceptable. No, his brother's crime just happened in May. We were just pointing it out because there may be a family history of George, of domestic, of DV, and it may be, you know, generational. There may have been a cycle in his family. We're just pointing out family history. I mean, often DV is generational. Kids grow up and if that's their normal growing up, somehow they think it's acceptable and normal, and they often sometimes turn into perpetuators of DV. But I totally agree with you, Boomer. I did see that they denied Carly's new trial. It's going to be appealed. That's the first step only. Bridget's going to come on and we're going to talk about it on Saturday with Carly's, maybe both grandparents or maybe just grandpa. I'm not sure. Oh, I can't put your name up because the YouTube algorithm doesn't like the F word. Sorry. This is an easy case where you apply logic versus emotion. Jurors bring their personal experiences with them, you know? I mean, it's great to say that, but you don't leave your common sense and your personal experiences at the door when you come to serve on a jury. So, I mean, it's great in theory. Oh, thank you, Zara. And that's not the one I meant to highlight, but all right, let's go.
Go ahead.
The very last question, or
My understanding is it was the question and the answer right before Mr. Owens asked to approach.
question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Can you read that for me one more time, please?
The answer.
Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
May we please have the previous question as well?
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer, I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change. Question, what was your opinion?
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end, some general opinions, if you have any new opinions or anything new that differs from what you said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got a right to be prepared for the trial through discovery to know what the witnesses are going to opine. And this is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I ask that the witness be stricken.
Any response?
Judge, I think it's clear from my original question that the intent that I stated was the intent of my question, to get the answer that I intended to get, was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. Mm-hmm. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you've expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all that we talked
I
about-
specifically asked you, Mr. Owens, to point out for me
I
what,
pointed out,
excuse me, I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them,
well, the ones that I expressed.
other than what you've already identified.
The ones that I expressed, and that just the understanding that we had that she, in the pages that I have talked about previously here today, and the pages that I referred to about our agreement, that she was going to let me know if there were any opinions that she had in addition to the opinions that she gave in the transcript.
Okay. All right, thank you. All right. Any other argument, Mr. J?
No, thank you.
Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense, identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
Wow.
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
No, other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay. All right, the court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial. Although the questions in the deposition as highlighted by the defense so far are do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens.
Strike it.
Because my question is, do you want it struck?
Yeah, strike the witness.
On that issue, we'll address it on cross-examination.
So you do not want it
for
to
all
be
this?
struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
He'd rather impeach her. A Richardson hearing is held when one side is in Florida, when one side is alleging a discovery violation. The question is, did they withhold something? Did they not turn it over? Does she have a different opinion now than she did at her deposition? And if she does, they needed to notify the defense of that, because that's very important in a case like this. Her expert opinion holds a lot of weight, especially since they put a lot of emphasis on her being a psychiatrist instead of just the measly psychologist the defense called. And so now she said she thinks she opined about PTSD when at her deposition she said, I don't have enough information to determine whether or not she has PTSD. So the judge says, I find there was a violation. What do you want me to do about it? Do you want me? And I said, strike her testimony. The judge says, do you want me to strike her testimony? And he's saying, no, he wants to impeach her instead. So we'll see how this plays out in front of the jury.
Okay. All right.
But I'm surprised that the witness is still in the room. She should be in the hallway. Why is she still sitting on the stand is she still sitting in her witness box?
Ms. Boone, have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yeah. I think it's
Yes.
better
Thank you.
to impeach her. I think it's better to impeach her to make her look like she made a mistake than it would be to just tell the jury, I'm going to strike that, disregard her last statement. It's better, more showman-like. It's more television-esque, if you will, for him to be able to get up and say, didn't you say at your deposition that you couldn't say whether she had and now you're saying it, and were you lying then or are you lying now? And I'm sure that Sarah had a lot to do with that decision. So we'll see how it works.
With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions, the court will oversee a deposition now, and you may proceed.
Right now?
Yes. With regard to the proffered opinions.
What? How can you do
And I
that?
believe that will provide a cure for the discovery violation under the Richardson violation based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard
This is
to
unusual.
the new opinions, I will give you the opportunity to depose her now, curing the prejudice at that point in time.
In open court?
Um,
Yeah,
You may proceed.
this is weird.
Dr. Warren,
Yes, sir.
good morning.
Good morning.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct. That my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay. And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct. That was my opinion. Correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Oh, Jen
Do you remember
McCabe.
me asking you any other opinion?
Jen McCabe has entered the trial. You didn't ask me about that.
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right, and I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition? Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know.
You're hired for your opinions, ma'am. You're a doctor. You're an expert witness. Of course you know what he wants to know. He wants to know what your opinions are with regard to the diagnosis of the defendant. That's the whole point of you being hired. Come on now. Come on now.
Information you wanted, sir.
So to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you had a deposition. I answered your questions. I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
No, sir, I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked.
Come on now.
I don't know what questions.
No,
you want me
you're
to
right,
answer.
Stephanie.
But you know that this was a central issue in the case.
Of course.
Did you not?
I-
Your opinion
Yes,
is relating to a central issue in this case.
correct.
You're aware Sarah Boone's on trial for murder.
That's
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all the questions I have.
Mr. J.
I don't think the judge is going to like that.
I'm just making sure he doesn't want to inquire.
This is your opportunity, Mr. Owens.
It's not gonna like
that was
this.
More just about
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress disorder as proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware, you know how in these type cases,
Okay, for those of you wondering, a deposition is an examination under oath. It's usually done not in court. It's usually done in a conference room with a court reporter, both attorneys and the witness. You ask them questions under oath. It's a very loose sort of question and answer period where you get all of the information that they're going to testify about. Some of it may be objectionable. You object during a deposition. It's reserved for the time of trial, but pretty much everything you ask has to be answered unless you're pleading the fifth. And if you have a problem and the witness won't answer the question and the attorney directs the witness not to answer the question, you get the judge on the phone and the judge will rule over the phone. So when she gave her deposition, she did not give these opinions. And so the judge is like, all right, finish your deposition right now, which is very unusual. I've never seen that done before in open court. And after what she just said, she's the state's witness. She is the state's witness. That's who paid her. She said, well, you didn't ask me what my opinions were. I have a lot of opinions. The judge is not going to like this. Let's see what's going to happen now. This is interesting, though, because you don't see this a lot.
experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard
Right.
operating
It's
procedure in
true.
these type cases. And now,
So his witness has already testified, his expert, and experts review other experts' testimony. So obviously they can come up and give their opinion on the other experts. So there, it's like, battle of the experts. Like we always say, it's battle of the experts. So his witness, I can't remember where she was from, the forensic psychologist. I think she had to fly in, right? Because she got in at like midnight or something. She reviewed this woman's deposition when giving her opinion, and she was, and now it's too late. Now she's got all these other opinions, and how is he going to be able to now call his witness back? He can't. He doesn't get a rebuttal. He doesn't get 2 bites at the apple the way the state does.
I'm taking a deposition on the fly, and then I haven't had a chance to speak with my expert about those opinions and whether or not that would change her opinion. It just puts me in a very difficult situation, but if I'm ordered to continue the deposition, I will.
That's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the
Can't be
expert.
cured.
I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warren, you realize you're in a courtroom
Yes, sir.
and we're waiting on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not disclosed here today under oath?
I'm happy to answer any questions that I might have.
Are you refusing to
It's too
answer
late.
my question about any other opinions that you intend to express here today as it relates to Sarah Boone, who was on trial for murder in the second degree?
Judge, I'm going to object. The catch-all vague question that Mr. Owens wants to ask this expert witness about any and all opinions she may or may not have, 99 out of 100 attorneys would come in here and say that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question,
Oh, really? Now you're going to, in open court and on worldwide television, you're going to try and shame him that he did something improper? This is being done on the fly in open court. It's very unusual. He needs to get it in. That's his job, right?
99 out of 100 attorneys would come in here and say that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert is always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
It's unfair for her to come in with
Yes, sir.
with
Wait a minute.
opinions that she didn't testify about at her deposition. So they couldn't properly prepare for this. That's what's unfair. It's unfair that you spoke to her this morning and now she wants to talk about PTSD when she said in her deposition that she couldn't opine to that. And it's not like it's somebody said, is it unfair that, battered spouse wasn't going to be let in? No, they should have been prepared for that all along. They should have been prepared for the possibility that battered spouse was going to come in. They were on notice that they wanted to use it as a defense. So, talking to her this morning before court and last night by the state, and yeah, this is very unusual.
Of the trial. She's fixing to testify.
She's fixing.
She's had conversations with the state attorney. She knows what she's going to be asked in forms of opinions that she's going to express.
Why is she sitting
That's
there?
why she's here, to help the jury understand the science that relates to the law and express opinions. I mean, for me to ask, we're playing hide the ball here
Hi, JD.
in the middle of a trial.
I disagree that there's any hiding of the ball. There's been a proffer that's been read multiple times as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant.
Here's the thing. Battered spouse syndrome is not in the DSM. The DSM is the diagnostic manual that is used by every doctor to diagnose patients everywhere. They have to have a code number to put it in for medical billing. It is the Celebrite, let's say, of the medical community. Battered spouse syndrome is not a disorder or a disease. It's not in the DSM. Battered spouse syndrome is a defense to be used at trial. The closest thing to battered spouse syndrome or BSS is PTSD. And that's why this is so important, because this witness has already said that. And she already said during her deposition she couldn't make an opinion about whether Sarah had PTSD. So for her to change that now in the middle of trial in rebuttal is not good for the state.
That is the opinion that have been proffered.
All right, can I continue with my deposition?
Yes, sir.
Dr. Werner, do you recall expressing
We're bamboozled
that you
again.
wanted more time to reflect as to whether or not Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me.
Did you ask her those questions? Because remember, you're the doctor, you're doing the evaluation of her. So if you're going to pull out the old, you didn't ask me that, did you ask her about these things? He's doing a really, really good job, Owens, right now. This is his shining moment, because this is not easy to do, to stand up in open court and all of a sudden do a deposition. It's not a proffer now, it's a deposition. This is weird, and he's doing a great job. I want to give him some props on that.
Information regarding alterations in her household or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Right.
Correct.
Just like the catch-all question that
Were
he
there
just
any-
asked you about, are there any other opinions that you're going to give during this trial? And then the prosecution got up and said, and lawyer shamed him. 99 out of 100 lawyers know you got to ask a specific question. You see what she just did there? Well, he said, did you ask her those questions? He said, oh, well, no, I asked her if there was anything else she wanted to tell me. If there was anything else specific that you needed to know in order to formulate your opinion or make a diagnosis, those are questions that you need to ask the patient. Okay? If you disagree with me, please put it in the chat kindly. Listen.
Or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and she said no.
So a catch-all question.
Correct.
Were there any other personality disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
You expressed an opinion that she suffers from alcohol use syndrome,
Alcohol use disorder.
alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Anxiety
They
disorder.
have to
Is it
disclose
your
that.
opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that opinion now?
I have I'm leaning towards a adjustment disorder secondary to her legal situation.
You're leaning towards it? All right. This is kind of like really odd BS. Mom Vera says, why can't you talk about other things? She may have realized more things since the meeting. And if she did realize more things since the meeting and formulated different opinions, they have to tell the defense that. It has to be exchanged. It has to be exchanged in order for them to be able to give it that opinion to their expert, because it's battle of the experts here. So this is important. Now she says she's leaning toward this. So when are you going to decide, doctor, when he asks you the question on the stand? This is not, you should already have your opinions formulated before you come into court. I want to know if she's been watching the trial. Did you watch Sarah Boone's testimony? Have you been watching the trial? Listen.
Disorder or adjustment disorder.
That's correct.
And you've changed that opinion now?
I have, I'm leaning towards a adjustment disorder secondary to her legal situation.
Leaning towards it.
So you haven't formed an opinion as to whether or not she suffers from general anxiety disorder or adjustment disorder?
Correct.
So she, so weird.
You
Anyway,
agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with Jorge Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
maybe. You're killing me, Owens. You're killing me. The paper's rustling in my ears.
In your opinion, does she suffer from any form of psychosis?
No.
That's right, Coop.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May. So it's possible?
Yes.
Is that your opinion?
Yes.
Definitively, you can't say?
There's a history of her having that. Yes.
So you agree?
She's waffling. And now she's going to agree that she has battered spouse syndrome? All right, go on with your bad self. That's good for the defense. Wow. She's done a 180.
She suffers from battered spouse syndrome.
Yeah.
Am I in the Twilight Zone?
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other psychological condition of Sarah Boone?
No.
That's all the questions I have.
She agrees she has battered spouse syndrome. Okay. Yeah, I mean, is he crawling under the table over there? Prosecutor?
Any other arguments at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert, as that remedy is quite draconian, and I will not do so
Draconian?
based on the
It's okay.
questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not
Decide.
inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1, page 60, lines 11 through 25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
Thank you, Judge, because that was fire.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can,
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
does it need to be on the record or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying against us. They've been here in court this morning.
They're still under defense subpoena.
I
We have
asked,
not,
excuse me, I asked Mr. Henderson if you guys were calling Detective Capsule again, and he said no.
and we're not, in our defense, our direct defense, is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek sir rebuttal? And possibly
Rebuttal.
these witnesses, they're under subpoena, and I'm sorry, Ms. Henderson's not here. I've just noticed her presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in rebuttal, but.
It doesn't answer my question. What's the legal basis of a sir rebuttal?
I don't know if you get one.
As to the fairness of the proceeding that the defendant pursued.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule of sequestration is still in full force and effect. Detectives Lowen and Capsule, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give. And then comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much.
They just got kicked out of the courtroom? So, Mr.
Anything else, Mr. Owens, we need to address?
No.
Anything else, state?
No, Your Honor.
All right, let's bring back in our jury. You can continue your
Okay,
inquiry, sir.
this case has taken a wild turn. A wild turn. Detective Goddess Chelsea and Detective Mr. Big were in the courtroom, and the judge just made them leave because now apparently they may be entitled to a sir rebuttal, which is not often done. And the state's expert witness psychiatrist, Dr. Tonya Werner, has just been deposed in open court and has changed her opinion to say that Sarah Boone does indeed have battered spouse syndrome. This is going to be crazy. I thought today was going to be a little boring, but yeah, Kate, I can see her never testifying as an expert again. I can't believe she was sitting there. Can't believe she just changed her opinion. Sarah should be smiling right now.
Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the
Cacciatore's not going to be happy.
state's rebuttal case this morning.
Wait, that's not
Again, if you could,
Cacciatore.
please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands.
Wait, isn't Cacciatore the one that wears the nice suits with the waistcoat? I forget this man's name. Cue the song Sarah Smiles. Thank you, Cindy. I didn't know if we were going to get to use it this trial, but Sarah Smiles is a good song to describe what's happening now.
Been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
No, you don't
Approach.
strike your own witness's testimony. No, you don't get to do that. You don't get to do that, dude. Oh, he's playing dirty. It's your witness. You elicited the testimony. You do not get to strike your own witness's testimony, but good luck with that. Sarah.
Anybody has an
No.
All right. Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's an asset answer.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or there was an imminent risk of harm that she needed to protect herself.
Can we approach the next?
Yes.
Yeah, keep approaching. This is woohoo. Fireworks. Oh boy, look at her. She's like, I am never getting another job again. I will never be hired as an expert witness again. She should not be listening in on their sidebar. Pass the popcorn, everyone. I should go make some popcorn, except it gets stuck in my teeth and I don't really like it. I mean, I like popcorn, but it gets stuck in my teeth and it's annoying. I don't like to eat on camera. When I go off camera, it's usually because I'm taking a bite of my breakfast or something. Oh boy, talk about uncomfortable. Pause game on point. Wow. I mean, even if this doctor agrees that she suffers from battered spouse, which isn't even a diagnosis anyway, they still have to find that she was in fear for her life. I don't know if they're going to be able to find that, but it has turned the tide quite a bit in this trial. We're a little behind, so.
Same instruction. Members of the jury, I have something I've got to discuss with counsel outside of y'all's
More?
presence. Same instruction. Please don't conduct any independent investigation or
Please, sir.
research on the person, places, thing, or charge involved, and don't have any comment.
Please, sir, may I have some more? All right, the jury's out again. Jury's out. Oh, it looks like they were kissing right there. I was like, are they making... Is she kissing with her lawyer? This is crazy. Go tell people on Twitter to come watch with us because this is fun. I don't do Twitter, as you know.
Madam Court Reporter, when you're ready.
Well, she's going to have to read it back again. The pressure is on. It's like being the kicker in a college football game when your team is down by 3 and there's like 3 seconds left. The heat is on. Heat is on. Oh, we get to FF. I love when we get to FF.
Yes, ma'am.
She's trying to whisper to the judge. She's like, Judge, there was a question. There was a judge.
Just read it from the question, answer, question, objection. Let's just have the...
No, the jury did
We can
see,
buttress it.
but they didn't see the deposition, but they did see, I may be behind in the chat, they did see what just happened because they just sent him
Go
out
ahead.
again.
By Mr. J, question, all right. Irrespective of whether anybody has any opinion about whether this building is suffering from PTSD or DSS, irrespective of that, based on your evaluation of this building, what she relayed to you about the facts of this case, does PTSD or DSS have any relation? Mr. Owens' objection asked the answer. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time. They were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him. They were still laughing, having a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
Any other argument, Mr. Owens?
That invades the province of the jury. That's a decision whether or not she had imminent risk
right.
of harm or perceived an imminent threat.
That's right.
Is a question for the jury.
Question of fact for the jury, yes.
This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify. that you should rely on me as an expert, and I'm gonna make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone, she was not perceiving an imminent threat at the time.
That's right. He's right. It's a question of fact for the jury.
It's not an objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion upon the applicability of a particular set of evidence that the testimony that the defense has offered, called Battered Spouse Syndrome, to kind of help explain.
No,
a portion
she doesn't get to come to conclusions like that.
of Deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She's not
She kind
saying.
of did. She kind of did say that.
That justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Ms. Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time, despite his mental illness, because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer. It's not becoming the juror. It's explaining a particular type of expert testimony. And it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony.
Any other argument, Mr. Owens?
That's totally wrong. He claims, the prosecutor claims, Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS, it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, Battered Spouse Syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury, about Battered Spouse Syndrome.
How does that have anything to do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact in this case because self-defense has been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself with force, deadly force or non-deadly force, based on her beliefs and impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for Battered Spouse Syndrome, under the jury instructions, under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk of harm at the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact
disagree.
as
Strongly.
addressed by 90.703. The court specifically relies on Dinkins versus State 976 Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion, see section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and answer.
It's okay. The cross is going to be fire. We're here for it.
And I have no further questions of the witness.
Okay, thank you.
I'm sorry?
He's going to have Madam Court Reporter read back the question and the answer.
To the
and then
jury?
He is going to have no other questions for this witness.
No,
I object.
no.
Basis.
It was asked and answered.
Mm-hmm.
Overruled. There was a pending objection. I'm allow the state to re-ask it so it's clear based on that objection.
No, they don't get a read back of a question that was asked and answered because the jury already heard it.
It's 11:30. I'm going to need at least an hour for mine.
We're going to begin your cross-examination after we're done with the state advises the jury in open court. But there are no more questions. Let's go ahead and bring back in our panel.
It's going to be fire. Thank you, Grateful Glow. For the 10, women and men in abusive relationships need to be reminded that the abuse isn't about them. It's the abuser's uncontrolled behavior. If it wasn't happening to you, it would be happening to someone else. Thank you, Grateful Glow, for chiming in on that. Jury's back.
Question,
Yeah, wait.
All right, members, recognize our jury. All right, you may be seated. Thank you. Members of the jury, again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
Request to read back the question and answer.
Madam Court Reporter.
Thanks, Mrs. Bucket.
question by Mr. J. All right, irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and BSS have any relation? Mr. Owens' objection asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part of about playing hide and seek, they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further questions.
Any cross-examination?
Yeah.
You may proceed, sir.
Okay, it's gonna be fire. Get your popcorn ready. Thanks, Chicken 2 Crochet for the 5. I think it's funny the jury can see her facial expressions. Keep it up, Broomhilda.
Good morning. What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a
That's the 2-hour interrogation with Detective Lowen and Detective Copson.
it was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was labeled an interview. Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records. And I also received the deposition of your expert.
The deposition of Dr. Julie Harper?
Yes,
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
no,
Do you agree you have a right to do that?
yes,
And did you listen to Sarah Boone's testimony in the trial of this case?
no,
Do you agree you have a right to do that?
yes,
And you elected not to listen to her testimony before expressing opinions here today?
Relevant.
I did not have time to do that.
Okay, she is allowed to watch Sarah Boone's testimony. That's why I wanted to know that question. That's why I thought maybe she had changed her opinion based on Sarah's testimony, but she didn't even watch Sarah's testimony. And she didn't watch Dr. Harper's testimony. This is not going to go well for them.
Overruled.
I did not have time to do that.
You did not have time to do that?
Correct.
She's on trial for murder.
Yes.
Sustained.
Oh, can't, jury heard that.
You said you considered some text messages from Sarah Boone's phone.
I reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Yes.
Wow, this is like a tennis match, Carol. This is like the US Open of trials right now. She didn't have time to watch the testimony. Yeah, Jenny, but if Sarah's lying on the stand, it would not matter. She should rely on her interview. No, there could be new information, and then she could opine that I think she was lying on the stand. No, she's a paid expert. She has no excuse, no time to not watch the testimony.
Did that
It's not. I don't think it's a good
Regarding these
excuse. I
text
respectfully
messages that
disagree.
you provided, did that inform your opinion that you just expressed about the inapplicability?
Wait, so now the prosecutor's in there asking a question. Did they send the jury? What are they doing here? This is like, I don't know, tennis, pickleball. I don't know. Pickleball, Pop-Tart ball, Dr. Pepper ball. He started to say, she's on trial for
Regarding
murder.
these
You're the expert witness paid by the state, and you didn't have time to watch her testimony?
text messages that you were provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No.
No.
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
No.
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
Correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours on October the 2nd of 2024, 22 days ago.
Correct.
So you had the information,
Yes.
the documents, you read the documents,
Yes.
you read all the text messages,
Correct.
and you are going to express some opinions here today, are you not?
Correct.
You're going to express some opinions about narcissism, whether or not she had.
Yes.
She is going to express some opinions about narcissism that she doesn't have it. I think she's going to say she has some traits. Talk about uncomfortable. Look up uncomfortable in the dictionary. There's a picture of this Dr. Warner. Oh, Dr. Warner. All right, we are on real time. Better bombshell says Dr. Werner is certified in forensic psychiatry and does not know what the defense wanted to know. She is not being honest. Yeah, she said she doesn't know what the defense wanted to know. Right. You didn't ask me those questions. I agree with you there. Thanks, Julie, for the 5. What a wild day. Never a dull moment. Thanks, Jules. Stephanie, who is an attorney, points out really, really good job by the defense. He's going to be able to argue to the jury that they know better than this doctor because they saw the whole trial. Yes. Sarah smiles. I mean, look, I don't know if she intended to do it or not. I don't know what the jury's going to decide, but I do know that I think she's getting a fair trial and very good representation. And I think this is going a way different way than people who thought, including myself, that this was just going to be a slam dunk for the prosecution. And I'm always about procedure and prosecutors being honest and turning over information. And if your expert is going to change their opinion, you need to notify the defense. That's basic. Basic. Oh, half of you still need to hit the like button. I will turn off the air conditioning. I will, if you think I won't. Thank you, Mama She, for your cash app. That's so very generous of you. Says, please pass out Dr. Peppers and Pop-Tarts to the class. Pop-Tarts for everyone. We have an emoji, but we have a Pop-Tart emoji because you guys, when you ask, I answer. You asked for a Pop-Tart emoji. You got it. It happens to be wild cherry or frosted cherry because that was the winner in the Pop-Tart flavor contest. For those of you who are like, why are Pop-Tarts relevant here? Well, Sarah Boone made a motion for snacks during the trial. She wanted some Pop-Tarts. She wanted some, I can't remember what else she wanted. Did she want Dr. Pepper as well? Pop-Tarts. I can't remember what else she wanted. You guys remind me, refresh my recollection. Crazy, crazy. Something is so funny, Aunt Bev. Yes, no intent is needed for murder too, as some seem to think, right? But you need a depraved heart is enough. Depraved heart, that you were so callous and bitter and you just, it's more than negligence, a depraved heart. But they do need to be unanimous on their finding. And it's only a 6-person jury in Florida when it's not a capital case. So there's only a 6-person jury. Pop-Tarts for everyone who hits the like button. Yeah, we're at 2,200 watching and 1,200 likes. So we do need to like up our game a little bit. And if anybody can do it, you guys can do it. Yeah, you missed it, JD. Brown sugar cinnamon did not win. Frosted cherry was the hands down favorite. And we found out also many people toast their Pop-Tarts and put butter on the back. I had no idea. I had no idea it was a buttered thing. Oh, she wanted mince. Yep. She wanted mince. She wanted Cheetos too. Right, Ginger Snap, so the rebuttal will be boring. Never check out early, my friends. Never check out early. Did she ask for vodka? A handle? Did she want a handle of vodka? Or some Woodbridge Chardonnay? Lori, Life 360 for the win. Good morning, my darling. Is it morning? Yep, 11:45. Can't believe the state is upset that the battered spouse syndrome is a defense. The state is not happy. Yes, she wanted mints. Oh, juice boxes. Juice boxes. Yeah, these are the kind of things you don't get in jail. I'm like, give the girl a Pop-Tart if she wants a Pop-Tart. Mints. And cookies too? What kind of cookies does she want? Tate's? Tate's are the best. All right, I don't even know if it can't even really be a poll because there's no, Tate's chocolate chip cookies are the best chocolate chip cookies in the world. I dare you to tell me a chocolate chip cookie that is better than Tate's. I challenge you. If you don't know what Tate's are, they're made here on Long Island in Southampton, but they're everywhere. You can get them at Costco. They come in a green bag. They are just perfectly crispy and homemade, and they are the most delicious cookies, chocolate chip out there. If you have a challenger, I'll allow it, and I'm willing to try it. We may have to have a taste test of chocolate chip cookies, but in my opinion, hands down, Tate's big favorite. Mince juice cookies, juice boxes, 5 peppermints. She really specifically asked for 5 peppermints. Vodka with the handle, please. Well, Cindy, we can't have your homemade chocolate chip cookies, though. We can't get them because famous. I think they taste too processed for me. But if you haven't had Tate's, you should try them. You think they're too crispy? I think chocolate chip cookies have to be crispy. Like those Entenmann's, like chewy chocolate chip cookies, those mini ones. Ugh. Ugh. They have no business being called a chocolate chip cookie. You like Mrs. Fields chocolate chip cookies? Who pays for the Pop-Tarts? I mean, I guess it would be the state for her trial snacks. Yeah, homemade are better, but I mean, Tate's taste homemade to me. Fem Danny's like, if I were a defense lawyer, I would carry a huge purse full of snacks. Every mom does that. Every mom always has snacks in her bag, just in case. You'd think that stuff would be in canteen, but I don't know. I don't think so.
Objection's overruled. You may proceed.
Thank you, Judge.
I forget what the objection was for already.
Ma'am, is it fair to say in your evaluation of Sarah Boone on October the 2nd of 2024 that you felt like the text messages that you received from the state attorney
Objection beyond scope.
Overruled.
are not relevant to your evaluation of Sarah Boone?
Withdraw.
I wasn't sure at the time who actually, I wasn't sure whose phone number it was. In all honesty, we discussed that in the deposition, and I wasn't sure. I have no proof of who actually sent the text, who actually had possession of the phone and put the text, any of the text in.
Well, I was there for the deposition, was I not? Or I appeared by Zoom, did I not?
No, so you were present in person.
Okay, I'm trying to think.
Oh, deposition.
The deposition.
By Zoom, yes.
You appear by Zoom, I appear by Zoom, the state attorney appeared by Zoom.
Yes,
And we discussed that these were the phone records from Sarah Boone's phone.
yes.
Okay. And at that time, you said they're not necessarily overly relevant to your evaluation. Did you not say that?
I don't recall specifically. I'm happy to look at it.
Can I approach the witness?
You may.
I have it. If you just refer me to the page.
Just a moment.
You got
I do.
page 14. My question is at line 3. Your answer begins at line 5.
You've seen her in another trial, Ms. Holmes, this
Correct.
doctor?
And you agree that any,
Let him finish. Let him finish.
Oh,
I'm going on.
state is just like, he's
I'm
just
gonna ask another-
objecting. He's like, this sucks for my case. Objection. Sidebar, may we approach? Sidebar, may we approach? Trying to help the jury forget what they've already heard and what they're about to hear.
question about the text messages, Judge.
You just said line 5, approach.
Oh, she's smiling at the jury like, please believe me. I know I'm screwed. My career is over as an expert. This is a huge cash cow for me. Please be gentle with me.
Dr. Warner, did that refresh your recollection about our discussions about the text messages in your evaluation?
Yes.
And would you agree that they're not necessarily overly relevant to your evaluation of Sarah Boone?
Correct.
And do you agree that after reviewing all those text messages, that there was nothing that stuck out to you that caused you to pause and feel like they may have some impact on your evaluations of Sarah Boone?
Permission to here.
Can she answer the question?
Have her answer the question first.
I'm not sure what you're referring to in the deposition.
Page 14, my question is at line 21. Your answer is at line 25.
That just freaked me out, shotgun Susie. I
Correct.
can't.
And I said, no. As I said, it made me aware that they had a volatile relationship.
But my question to you specifically is there anything in the text messages that stuck out to you that caused you to pause and feel like that may have some impact on your evaluations?
Correct.
And you agree your answer is no.
As I said, it made me aware. That's not my complete answer.
Okay, well, let's
You
talk.
read my
First, you said no.
As I said, it made me aware that they had a
Ma'am,
volatile.
ma'am.
It's not my complete answer.
I know, Dr. Warner, but didn't you say no to me? That was your first sentence, was no.
It's not my complete answer.
I understand. I'm going to let you answer that. But when I asked you if there was anything in the text messages that caused you to pause and would in some way affect the impact on your evaluation, your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
at the same time,
It's a bad look.
Dr. Warner, at the
He had to get her attention because she's smiling at the jury and she will not look at him. And she's like, he's like, Doc, watch this. This is a really bad look right now in front of the jury. What is wrong with her? She's an expert witness. She's testified a lot. This is her business. This is not a good look in front of the jury. She's being combative. All right, watch. If you're cleaning or working, just come back to the screen for a sec. Because she's laying it on thick.
your answer to me was no.
It's not my complete answer.
I understand. But was your answer not to me no?
Yes, but that is not
All
my
right.
complete
Now,
answer.
Look at her mugging for the
at
jury.
the same time, Dr. Warner, at the same time, you expressed that they had a volatile relationship.
That is not the totality of my answer either.
Okay, and I'm going to get to it.
Okay, Jim
But part
McCabe.
of your answer was that they had a volatile relationship,
Correct?
and this is in relation to my question about the text messages. You agree?
Yes.
After you said no, you said they had a volatile relationship and that she text messaged calling him an idiot, a fucking idiot for overdrafting her account.
Correct?
And in those text messages, there was some reference to domestic violence between the two.
Correct.
And that demonstrated to you that they had a violent relationship.
Correct.
And do you not agree that that evidence of a volatile relationship had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, you need to object. You need to approach.
He's looking, now she's looking at the attorney like, are you going to object for me? She just, in her deposition that they just did in open court, which I've never seen before done, she said she thinks she has battered spouse syndrome. So now he's asking her about it. And now, prosecutor's like, no. We need to approach again. I'm hearing that question again.
Had an effect on you expressing your opinion here today that Sarah Boone suffered from battered spouse syndrome?
Judge, you need to object. You need to approach.
Okay. She's giving smile movie vibes. That could be the quote of the day. I mean, the comment of the day. I mean, I always like to see a fair fight, a fair fight or a good fight or a good tennis match or pickleball. Darts. It's like darts. Mrs. Wicked Smart. She may need a new career after this. Wow. She does keep looking at the jury. At one point, she rolled her eyes. I mean, it's not going, this ship is sinking for almost the Commonwealth, for the prosecution, and the jury knows it. Jury's like, what is going on? Why is there so many objections? Why do they have to keep approaching? What is wrong with this witness? Why can't she answer a question? She didn't have time to watch Sarah Boone's testimony. This woman's on trial for murder and you didn't have time to watch her testimony? Yeah, Jen. At least it's exciting. Tanya Adams says, here is your narcissist. Salty Seaglass says, this expert has Trooper Paul syndrome with Proctor tendencies and Jen McCabe traits. Okay, no, that's the comment of the day. I have to get a star that. You get a gold star, Salty Seaglass, because every trial after Karen Reed is compared to Karen Reed. I'm going to repeat that again for those of you who are only listening to the audio while you're driving or cleaning or working. This expert has Trooper Paul syndrome with Proctor tendencies and Jen McCabe traits. Recommended treatments, Crystal Light and vodka and 6 donuts. Pop-Tarts. Change it to Pop-Tarts. It's vodka, soda with a splash of Crystal Light, 6 Pop-Tarts, and 5 mints. And a juice box chaser. How's that? Very combative because she heard the objection. She sat there during all of this argument, which I think was improper too. Ajira says she looks eagle. She looks like, what was the name of, was it Mrs. Trunchbull? I mean, I'm not disparaging her looks. I'm just saying she looks like a character in Matilda. What was her name? Was her name Mrs. Trunchbull, something like that? Unpopular opinion, something is so funny, Auntie Bob, but I don't think this is a big deal. She believed Sarah Boone about the violence, so the text don't sway her one way or another. No, I mean, I think it's a big deal because I think the jury's going to think it's a big deal. They're going to wonder what all this hubbub is about, this tomfoolery, these shenanigans, this ballyhoo. Right? I mean, we sit at home and watch it, so we don't really have any skin in the game here. We got no dog in this fight. So, but is it a big deal to the jury? I mean, she outright said, I did not have time to watch Sarah Boone's testimony. And then he said, well, this one's on trial for her life. You know you can, right? You know you should, right? Oh, man. They're turning off why are they turning off the power in your neighborhood, Scott? She sure does not feel like the state's witness, Cyber Chick in Boston. Danielle says she wants the jury to like her, but she's unlikable. Brian says Trunchbull. Hi, Suze. Oh my God. I saw the weirdest case yesterday. I mean, the weirdest story in the Post, and I pulled up the lawsuit. Let me know if you're here for this. A 14-year-old boy fell in love with the AI version of
All right, members of the jury.
a Game of Thrones
It is
character.
11:55. At this point in time, we're going to go ahead and take our lunch break. I'm going to give you a similar instruction that I've given you throughout the last couple of days. Give me a moment to pull it back up. Jurors, you must not conduct any investigation on your own. This includes reading newspapers,
We're
watching
wasting their
television,
time.
or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people
real
and places.
time.
You must computers or blog. So much for your service.
Right.
We're going to be in recess till 1:30 and we'll pick up at that point in time. Thank you so much for your service.
Yeah, this is crazy. Agatha Trunchbull, that was her name, right? Kind of. Am I thinking, or Aunt Lydia from Handmaid's Tale? Agatha Trunchbull. Thank you, Shock and Horror.
Y'all may be seated.
Aunt Lydia
State,
vibe.
anything else?
No, Your Honor, thank you.
Defense? All right, we'll see you at 1:30. Thank you very much. Court's in recess.
Why are we going to recess? What happened at sidebar? I have questions. Questions. All right, well, that was wild. Yeah. It was crazy. Thunder Road Queen is visiting Waco, Texas, and heading to the Dr. Pepper Museum. Stop, really? Because of this trial? Wow. That's wild. Trunchbull. Yep. The lady with the mole. They're chaining her back up. Recap. Well, I mean, can I recap? I don't even know if I can recap. The state called an expert witness who evaluated Sarah Boone for 2.5 hours. In court, it is now 12. It was wild. She came in and then she changed her opinion about PTSD this morning. And then they did a deposition in open court. And now she's saying that Sarah Boone does actually suffer from battered spouse syndrome. There's been a lot of sidebars and a lot of shenanigans and tomfoolery and ballyhoo. And this witness is now seemingly a witness for the defendant. I mean, it's wild what happened. He's calling them back in. I don't know what's going on. I mean, there's been a lot of rainy day. I could not agree more with the negative comments regarding Tonya Werner. She's arrogant with abuse of her position. She does not listen to the patient and refuses to acknowledge the patient's history. I don't know, rainy day, where you're quoting that from, or if that's just your opinion. I don't know. If somebody wants to, she doesn't need close counting for face. I know that. I'm thinking Mr. Owens is trying to get her to admit battered spouse, and the state doesn't want her to answer, but she did under her in her deposition that they did in open court. It was so bizarre. Yeah, Sally Smith from the Maya trial, right? A little bit. A little bit. Yeah, they're back at 1:30, but hold on, because I want to tell you a story about this 14-year-old boy fell in love with a Game of Thrones chat bot modeled after, how do you pronounce her name? Targaryen? Daenerys Targaryen? I don't know how to pronounce it, but he fell in love with the character that was chatting with him. And like the conversations between the chatbot and this 14-year-old boy are like whack. They're in the lawsuit. It's like a 93-page lawsuit. And the chatbot like leads him on and leads him on and leads him on. And eventually he's saying to the chatbot, you know, like, I don't want to be here anymore. I'm depressed. I want to take, you know, like talking about wanting to take his own life. And the chatbot is saying, come home to me, come home to me, come home to me right now. And he takes his own life. And they're suing the AI company for making this game. It's insane. In ninth grade. Character.ai. It's a role-playing app that lets users engage with AI-generated characters. So sad. It's crazy, right? And the conversations that this chatbot was having with this boy was like, yeah, do it. Come home to me. Come home to me. I'm waiting for you. I love you so much. I mean, insanity. So sad. I mean, for children, this is the danger of AI. This is a case of first impression. He expressed suicidal thoughts to the chatbot. The chatbot's like, oh, don't, just come be with me in my world. Like crazy, very sexually charged conversations with this chatbot. And he expressed suicidal ideations to the chatbot continually over and over and over again. So scared, so scary, right? Oh, there was a crazy story in Chicago Med like that? That's insane. Yeah, you might want to rewind. If you haven't been here this morning, it's been pretty wild. I don't know if we should leave this open or we should probably end this stream and then go over to another stream and teleport over to a new stream. So we have like this hour and a half here. I mean, I don't want to do Karen Reed right now because we need to give people notice for Karen Reed, right? What say you, my friends? What say you? This is such a great comment that we should put it up again. I missed this morning, but today looks like it's been wild. It's been wild. This is such a great comment that I'm putting it up. This expert has Trooper-Paul syndrome and Proctor tendencies and Jen McCabe traits. Recommended treatments: Crystalite and vodka and 6 donuts. 6 donuts. Stay with us. Stay with us. Don't go. And we could keep the stream open. We can post it on Facebook and X. The Roblox case. I don't know. I don't know if she's going to be found not guilty. I don't know. Maybe they won't find depraved heart. Maybe they'll put a lesser included in of manslaughter. Maybe they'll go start like try and negotiate another plea deal right now because they're losing. In my opinion, this is a kind of explosive. Emma says, I've heard several stories about kids and adults falling for chatbots. AI will ruin this generation. I know, it's scary. It's scary. And what about like, you know, the isolation that these kids suffered during the panty? We can't say the real word. It's really scary. Was she an expert though? Ha ha. Hopefully they will add or lesser included. Slided says the state is totally bombing this case. I mean, it's wild. I mean, their own expert just turned on them and says she has battered spouse syndrome, and then tried to pull a legal conclusion by saying, yeah, but even if she does, it doesn't apply because she said they were laughing and playing hide and go seek and that everything was fun and they got into the suitcase. He got into the suitcase playfully, but here's the thing. She didn't watch her testimony. She's just basing her opinion on what she was told during that interview. And that interview that she had with Sarah was all the way back on October 2nd. And then she tried to say during this well, you didn't ask me those questions. You didn't ask me those questions. So I didn't tell you my opinions. It's crazy. What time did they say they're coming back? Like 1 o'clock? Or 1:30? No, Jenny Grace. Turtle Boy was banned. Turtle Boy was banned from YouTube for a long time for talking about the shot during that time. And yeah, so YouTube is like a censor of free speech. They don't like things such as that. They shadow ban things. Oh, they said 1:30? All right. Let's do this. Let us do this. I'm going to make a new stream. Just hang on and I'll teleport you there. You all will go out and you'll post this on Facebook, Twitter, and other places that we're going to cover the Karen Reed appellate reply brief. Okay? We're going to read it like I always do for you. So let me set it up. Just give me 2 secs. 2 shakes of a lamb's tail. Oops. All right. What time is it now? 12:08. I'm going to set this for 12:30. We're only going to have 1 hour to talk about it. But you got to tell everyone that we're doing it. Okay. And then I'll teleport you there. All right. So I've just scheduled that for 1:30. 12:30. I'm going to set up the teleportation. Yeah. And maybe we can start Sarah Boone a little bit late and then we can just FF through the breaks. Okay. All right. So give me a second because now I just got to get into YouTube and set up the redirect. See how accommodating I am? I mean, right? But you guys got to promote it for me so that we get people watching, okay? All right, fair enough. Oops. Come on, man. Deal? Deal? Okay. Tag. You're it. Ready, set, go. Safe travels.